Thank you, everybody, for joining. I'm going to try and keep this to an hour or less if I can. There's a lot to cover. I want to make sure that everything is covered so that you guys understand exactly what's going on, or at least what's going on as of today. The disclaimer that I give for all these talks is that the information is only good for today. The stuff changes so rapidly, don't know what's going to happen after today. Don't know what new laws, rules, regulations, or what have you are going to come out. So anybody that's listening to this on a recording, it's probably obsolete, or at least part of this is obsolete. So try to get whatever new laws came out since this recording so that you're up to date with it. And Priya, if you could go through the chat as we go along, if anyone has any questions, just put it into the chat. Priya will go through those and we'll try and get to those in turn as we go. Okay, I want to jump right in. Okay, so first I just want to start with the federal laws and what's going on there. So the first thing that you need to make sure that you're still keeping up with is if you have a covered property under the CARES Act, and this is from way back in, I guess, March, April 2020, when the CARES Act was originally passed, which we all thought was over now, but apparently it is not, in the sense that if you do have a covered property, meaning that it's property that's, for your purposes, probably a housing choice voucher property, or a property where you're getting, it's insured by either, or the, strike that, the mortgage is either a Fannie Mae or Freddie Mac mortgage, then you are considered a covered property. According to the government's guidance now, they're saying that you still have to give the notice before you file an action to evict. Under the CARES Act, you still have to give that notice. We thought it was over. If you talk to attorneys, like I have done all across the country, we all believe that you do not have to give the notice. But what do we know? The government is saying that you do. So in an abundance of caution, we're recommending to everybody that if you do have a covered property, that you should still give that notice to quit before you go ahead and file for an eviction case. Okay. Next thing that's happening on the federal level is the CDC moratorium. Extremely confusing. I'm going to try and break it down. I'm sure you guys have heard a lot of different things with regard to it. I'm going to try and make sense out of it as best as I can. Very difficult because it really doesn't make sense to a lot of people, including myself. But I'll try and explain to you sort of where it's at. Back last year during the Trump administration, the CDC came out with a moratorium, said that basically you cannot proceed to evict somebody. There was a lot of confusion around whether or not you could still file an eviction complaint, whether that was considered a quote unquote eviction. Courts are still confused about that. But the general consensus is you can file an eviction case, you can go to court, you can get a judgment against the tenant, but you can't actually lock out the tenant. So the word eviction is being construed to mean you can't lock out the tenant. That happened during the Trump administration. Then Congress came along, they extended that moratorium. Then the president, when Biden got into office, he extended it again. That moratorium was set to expire at the end of July of this year. There was a case, there's actually a lot of cases, but one case that worked its way to the Supreme Court that was filed saying that the CDC moratorium was unconstitutional. Went to a district court in Washington, D.C., and the judge agreed, said the CDC moratorium is unconstitutional. The lawyers for the government went in and said, however, we need a stay. We need to stop the order from going into effect, declaring it unconstitutional while it can work its way through the appellate courts. It then went to the circuit court in DC, and they continued to stay, and then it went to the Supreme Court of the United States. A decision came down in the middle of July of this year in the Supreme Court of the United States. And here's where it really gets confusing if you're not confused already. Okay. 4 justices said it's unconstitutional. 4 justices said it is constitutional. So we had a split. Judge Kavanaugh was the deciding vote. Judge Kavanaugh issued a decision where he basically said, and it's what they call a concurring opinion. So he wasn't siding with the majority in his opinion, in his reasoning, but his ruling, or his which side he came down on, was he said, I'm going to declare it constitutional and allow it to stay only because there's only 2 weeks left on the moratorium. The CDC has said they are not going to extend the moratorium. And therefore, I would like to see the rental assistance that's out there come into play for the next 2 weeks, and we can have an orderly transition. So while he said it was constitutional, he really said it's unconstitutional, but I'm allowing it to stay as constitutional because it's going to expire in 2 weeks. He also said that it's up to Congress to extend the moratorium. Okay, so even though there was a 4-4 split and he is siding with the side that says it's unconstitutional, he actually voted that it was constitutional. So you ended up having 5 justices say it's constitutional. His qualifications were just his qualifications. They weren't the qualifications of the other 4 justices. So we all know logically, if this goes back to the Supreme Court, what's going to happen, he's going to side with the other 4 justices, and we'd have a 5-4 decision saying that it is unconstitutional. But we don't have that yet. Okay, so what happened was the president said back in July that I cannot extend the CDC moratorium because it's unconstitutional. He said that it's up to Congress to act in accordance with Judge Kavanaugh's decision. Congress had an opportunity to act. Congress did not act. The moratorium expired at the end of July. The president then scrambled. He realized that he was going to take a huge political hit for this. So he came out and he talked to the CDC and said, find some way to extend the moratorium. The CDC then came out with an order, as you all know, extending the moratorium until October the 3rd. The president is in his press conference before this all happened, pretty much said he knew it was unconstitutional. And we all know what's happening here. He just wants to extend it, knowing that it's going to take weeks, possibly months, to work its way through the court system. And all the while, the CDC moratorium will stay in effect while that happens. Attorneys last week went into court on that original case that was filed that went to the Supreme Court. It's a case out of Alabama that was heard in the DC federal court. Went back to court and argued that this is unconstitutional, that what the president did is he knew it was unconstitutional. He did it anyway. This should get overturned. The judge in DC court said, while I agree and I already ruled it was unconstitutional, I was overruled by the Supreme Court because they issued that decision saying it was constitutional. Even though Judge Kavanaugh is saying it's not, and he's going to side with the other side when it comes up back to the Supreme Court. As it stands right now, the precedent that is out there is it says it's constitutional. She said, my hands are tied. I can't do anything. She allowed it to stay in existence. This all came out on Friday of last week. I'm sure the attorneys have been working over the weekend. Not sure whether they're going to go to the Third Circuit, to the DC Court of Appeals, or they're going to go right into the Supreme Court. But it's going to work its way to the Supreme Court. The only question we have right now is how long is that going to take?
Paul, yeah, do you have any sense of what that timing may be?
No.
Okay, me neither.
Yeah. When the judge heard the case in District of Columbia, she basically said, I'm going to make a ruling in the near future. So, what do I know? I thought it was going to come out in a day or two. It took her 3 days to issue a decision. So how quickly it gets to the Supreme Court and how quickly the Supreme Court's act is anyone's guess. But where we are right now, so that you all understand, is the CDC moratorium is in effect until October the 3rd, until it gets overturned. Do I think it'll get overturned? Yes. Do I know when? No. have I given up predicting anything during the COVID-19 period? Yes, I'm out of the prediction period. I thought this was all going to be over by May of last year. So what do I know? Here we are, and we're still going. All right. So anyway, that's what's going on the federal level. And I hope that sort of clears it up for you to give you a sense of what's actually going on with this, because you hear a lot of conflicting things with regard to it. But that's actually what's happening. Next thing I want to talk about is what's going on in Philadelphia, which is another nightmare, confusion, call it whatever you want. Something we're all trying to sort through and figure out. But we'll try and give you a general sense of where it is today. And once again, that's for today. Don't know where it's going to be tomorrow, especially in light of what might happen with the CDC moratorium. In Philadelphia, what's happening is that there was last year the Emergency Housing Protection Act that got passed. And there were certain provisions that were put into that law that gave the tenants a lot of protections. So one of those protections is that before you file for an eviction case, you have to send them a notification of their rights. You have to notify them of what their rights are with regard to the Emergency Housing Protection Act, and basically what their rights are with regard to rental assistance and everything else that's going on with regard to protections for tenants. The other thing you have to do before you can file an eviction complaint is you have to file for rental assistance. Once you file for rental assistance, you then have to wait 45 days before you can file an eviction complaint. The problem with rental assistance right now, as Greg will tell you, and because he's been studying these numbers and knows them in detail more than anybody else, is that rental assistance is not going to cover everybody that's applied. In fact, if you look at the numbers as of Friday, there was over 47,000 applications, of which a little over 10,000 have received the money. So that's less than a quarter of the people that have applied so far. And mind you, people keep applying every day. There were 2,500 applications alone last week. Okay. The government has approximately $135 million, or had, and still has, the remainder of what hasn't been spent, of which 78 million has been spent. So just doing the quick math, you will see that over half the money has been spent, and it's been given to less than a quarter of the applicants. What does that mean? That means less than half the applicants are going to get the money, the rental assistance. And mind you, the people keep applying every day. So do you think anyone that's applying today has a shot of getting rental assistance? I don't. But like I said, I gave up predicting, so we'll see what happens. Will there be more money appropriated? Don't know. $46 billion that was appropriated nationally is a lot of money. Are they going to appropriate any additional money? Your guess is as good as mine, but it won't happen quickly. The city is saying that the money is going to run out in approximately 5 weeks. That means in 5 weeks from now, there'll be no more rental assistance. You're still, however, I'm guessing, going to have to apply for rental assistance before you can file an eviction case. Why? Because they don't want you to file eviction cases. They want to put this off as long as they can. So I'm guessing they're still going to make you apply for rental assistance, even though we all know you got no shot at getting that rental assistance. It's absurd. The city recently just came out with another order where they said that as long as a case is being reviewed, or I guess the word they used, if the application is completed, you cannot evict that tenant. You cannot file the alias writ and throw that tenant out of their property if they have a quote unquote completed application.
So 1 second, please. Does that mean if it's under review or if it's completed?
Great question.
Great question.
We're trying to find out what the definition of completed is. In my mind, it's the opposite of an incomplete application. I know what an incomplete application is because the city comes back and says your application is incomplete, and they check off the box when you go into the website to look at what the status is of your different applications, there's a box that says incomplete. So would one assume that if it doesn't say incomplete, it's complete? Maybe. Are judges going to interpret? Are judges going to interpret that way? Not really sure how they're going to come down with regard to that. The problem you're going to have, well, there's lots of problems you're going to have, but one of the problems you're going to have is even if it's completed, doesn't mean they're getting the money. The money's going to run out. Does completed mean approved? Like, we just don't know. I think I hate to guess what the city's trying to do, but they use these broad terms and it covers so much more than it actually should. If the person's got the money, then they shouldn't be locked down. I get that. Or at least approved so that you as a landlord know you're going to get the money. Just completed doesn't mean anything to you. So it's not a good position for us to be in. So the bottom line is that those lockouts aren't going to happen. You're not going to be able to do a lockout anyway under the CDC order, at least until October the 3rd. But I guess we'll have to see what happens with regard to that on the federal level. But locally, they have a completed application. They're going to show it. You're not going to be able to go ahead and proceed with the eviction.
So will we be able to file the first writ if it's under review? We can file all the writs anyway. We just might not be able to proceed with them, correct?
So you can file all of that, but yeah, you're not going to be able to conduct a lockout under those circumstances.
Right.
And then the other thing I wanted to mention that was as part of the court's order, they said that if you filed a writ of possession prior to May the 1st of this year, you have to refile it and reserve it before you can go ahead with the alias writ.
Paul, just one clarification on that. I think the language in that order says if your writ of possession was served prior to May 1. So if that writ was served prior to May 1, you don't have to file a new writ. What you have to do is notify the landlord tenant officer and pay another $45 for the writ of possession to now be reserved. And then you can continue on with your alias writ and execution of the alias writ, so long as there's not a CDC declaration in effect or the rental assistance application is complete. And once again, nobody seems to know what that really means. Complete or is submitted. We don't know what that means yet.
So how far back can we go for the reservice? Do you know?
Well, if your writ was served on or before, prior to, I believe it's prior to May 1.
That's
so
correct.
If you have a writ of possession that was filed and was served prior to May 1, meaning April 30, then you got to spend $45 and have them go out there to give the tenant in essence, a notice that they're about to be evicted. I mean, the thinking behind this, and I had some conversations where supposedly some of these decisions are being made. And the explanation was that for argument's sake, and we all have these, we may have a judgment for possession that was entered back in January of 2020, pre-pandemic. And then just because for different reasons, that eviction did not take place prior to when the pandemic was announced mid-March and the court shut down. So you have people who had a judgment entered 18 months ago, 19, 20 months ago, got served with a writ way back, but then everything shut down. So the alias writ never got executed. And the explanation the court gave to me was that, these people have no idea that this eviction was coming, that the alias writ was being executed. As you may know, in the last couple of weeks, alias writs were executed and people were put out and they came running and say, I don't know anything about this. Of course, they never know that they didn't pay rent for the last 20 months. They didn't know that they had a hearing and a judgment entered against them. Be that as it may, and the unfairness, but we're kind of used to that at this point, not happy with it. But despite all of that, the court is taking the position, these people need to be re-notified that they're about to get locked out before we let you lock them out. That's bizarre, but that's what it is.
We can go all the way back then.
Oh, absolutely, because they're making us do this. You're going to have to do this. You will not get an alias writ executed. And I'm sure the landlord tenant officer is very carefully looking to see when did they serve the writ. I know we're looking to see when was the writ served. You know, we get the affidavit of service from the landlord tenant officer. It's not hard to determine when it was, and if it needs to be done, we need to send $45 over to them. So they go out, give them a notice, and then they'll execute the alias writ, again, assuming you don't have a CDC or an application that's, you know, complete, whatever the hell that means. Nobody's told us what that means. So it's bizarre, but you know what? We're kind of used to bizarre.
Yeah, and Kenny, do you want to explain the 180-day rule too? So
Well, I
people
think
understand that as
I
part of
believe,
this.
and again, they've made every single thing that they're doing. They've tried to make it as confusing or anything but succinct, so that you know, we would understand what it is. And I believe for a long time, and Paul feels the same way, none of this is unintentional. I'm sorry, all of this is intentional. They want to muddy the water so that we don't know which end is up, and so that they can run in and get an order, get a judge to stop this or that. My understanding is that during all of this, everything that we've been dealing with throughout the last 20 months or so, that 180-day rule is being waived or has been waived. I have not come up against a situation where we've had a problem with that, but who knows what's coming down the pike. But right now, the least of our problems is the 180-day rule, I think.
No, Kenny, we're actually running into a lot of problems with that 180-day rule. And what happened was the courts have suspended the running of the 180 days, and don't hold me to the dates, but I believe it was from March the 15th of 2020 through, I believe, May the 1st of this year. The 180 days rule doesn't apply. It's been told.
Right, during that period of time, yes.
Right, but if you have a case that was filed prior to that date in 2020, prior to all this stuff happening, and you were trying to do a lockout, and then there's also all of a sudden a moratorium, you couldn't do the lockout. Those 180 days are running. And the court has said that unless you file for an extension of that period, while the period hasn't expired, the judge is most likely not going to grant you that extension. So if you have one of those types of cases, be very careful to make sure that you go ahead and file for the extension of the 180-day rule before that period expires.
Does that count from the day that you filed or from the day that you went to court?
Date of your judgment, day you were in court.
Good answer.
That's when the 180 days starts to run. So you would take that period from prior to the 15th of March, and then the period after May the 1st, assuming that's the exact dates, give or take a month, either 30 days either way. But that's what you got to look at. All right. And then the other thing I did want to mention is that the court has basically stayed all of the landlord-tenant appeals cases. So all those cases where you have an appeal of a landlord-tenant judgment that was in common plea or is in common pleas court, that you had a hearing set up, those hearings have now been continued, and it's now going to go to a status conference first before you can get before a judge. So it's another delay.
We just got a load of conferences coming up in September on appeals that have been pending forever. Since prior to March March 15 of 2020. So they're beginning to conference those cases, and then I don't think any of those conferences have necessarily taken place yet. I'm unaware, but they're coming up in the next week or so, and then moving forward. And then we'll have some idea of what they're doing with those cases, with those appeals that are sitting in common pleas court. And I understand, Paul, there's also issues with getting an order to terminate a supersedious in the interim. They've stepped all over us and what the procedure procedure is to prevent that from happening, where someone is not escrowing monthly rent into common pleas court with the prothonotary, where we ordinarily would simply take over a piece of paper, terminate the supersedious, and proceed with the eviction. I think they have that kind of on hold as well. They're just not letting us do that either.
Okay, and then the last thing I did want to mention was that if you do get rental assistance, that from the last day that you've gotten that rental assistance, you have to wait 90 days before you can file for eviction. And if you don't have anything else, Kenny, we can start answering some of these questions.
The only other thing I'll add is that once again, I was told that there may be, and God knows how long this will take, but I don't think it's going to happen quickly, that they may actually put people in the courtroom or outside the courtroom to assist with the rental assistance and or the applications. They haven't been able to handle the rental applications that have already been submitted over time. I'm not sure how quickly it'll be if they ever set this up for literally in the courtroom or outside the courtroom to assist. But I think the last thing that they really want to do is try to move the program along. They're doing everything they can to keep it at a snail's pace. So I'm not holding my breath on that, but we'll find out soon enough.
Yeah, the other thing with regard to that is anyone that's applying in court is not getting rental assistance. The money's going to be gone.
Yeah,
So
it's probably
it's
going.
just, it's just another delay that they're going to create to stop you from being able to proceed with the eviction, where we all know that they're never getting the rental assistance, and that's all it is just another delay.
And one other bit of information, I think I saw a question that may have been posed, but the relative to, can you file an eviction action? And let's assume you haven't received any assistance. Let's assume you sent out the proper notifications under the CARES Act and the diversion programs and so on. Can you file your eviction complaint? The answer is yes. Can you have a hearing? Yes. Might you get a judgment? Yes. Can you file your writs? Yes. Will you get a lockout? No. So you can do all of these things. And so the question may be, well, why bother doing all of this? And I suppose the answer at the end of the day, you got to do what you're comfortable with in, doing. But so, I to my way of thinking, the sooner you get the process started, then whenever we see a light at the end of the tunnel, the closer you may be to getting either an eviction or now putting a tenant up against the wall where he or she has to pay or understands that they have to pay. I mean, up until now, they've all been convinced they can sit, not pay, not do anything, and not be affected by any of this. So again, do you wait? Do you move forward? Good question. I just think I'd rather be a little bit ahead of the curve than totally behind the curve, for what it's worth.
Okay, let's go through these questions. Do you still have to apply for rental assistance even though your eviction is unrelated to non-payment? Kenny just addressed that question. The answer is no, you do not. Next question is, what about filing for possession only? At this point, just want my property back. That's not going to help you. If the eviction is based on non-payment of rent, which it basically is, it's not a breach case, then just filing for possession isn't going to help you in that situation. Are you still prevented to file for eviction if the application is complete, but the lease is terminated? The answer is yes. They consider the termination, especially if it's termination not for cause, just termination at the end of the term, then they're still going to consider that a completed application. You're not going to be able to proceed. Are we still required to pay real estate taxes, water, trash, refuse, clip violations? Did the CDC stop these fees for landlords? No, you're still obligated to act as a landlord and do everything that you're responsible for doing. It's a great argument. I like it, but unfortunately, it's not going to help you. Is there any possible way we can file a lawsuit against city courts as they have taken our rights away as landlords? That's a great question. Nationally, there's a lawsuit that has been filed It was filed on behalf of attorneys through the National Apartment Association. Any landlord can get in.
Oh my God.
Paul, you are muted. Paul?
Okay.
Yeah.
Did that just happen or was that a while?
No,
Okay.
I-
Bottom line is there's a federal lawsuit that's going on. You can join that federal suit. They're trying to get the money back that is owed to them. Couldn't you go ahead and sue the city as well? Sure. And it'd be based on the same theory as that they have on the national level. You just add in whatever the city's doing and make it a city case. It just gets very, very, very expensive to bring such a case, which is why if you're really interested, I suggest that you join the National Apartment Association's lawyers case. Costs you $1,000. You're named in that case. And if there's any recovery, you would get whatever you were entitled to. Keep in mind, though, that if you are getting rental assistance and you're being reimbursed, you're not going to get any money under the lawsuit. It's obviously only for money that you've lost as a result of what they've done. Are they locking out commercial tenants? Yes, I believe so.
They
Kenny,
are. They are. Commercial tenants can be evicted. That's not necessarily stopped other than, again, they can apply for the CDC. All of that's going to apply, in my view, just the same as residential. I mean, I think the lockouts, you can look at all of this as under municipal court and landlord tenant procedure and so on. I think it's all the same, whether it's commercial or otherwise.
Okay, if you have possession judgment, will the lockout for breach possession no money? I don't understand that question. I assume that's in the commercial context as well.
Say that again, if
you have possession judgment, will the lockout for breach possession no money?
there's no reason not to be able to proceed. I mean, the one thing we don't have to worry about with commercial properties is the good cause aspect of if you're terminating or the lease is over. None of that applies in commercial, it only applies for residential. But again, whether it's breach, whatever the situation may be, the moratorium will stop us. Now, that takes us back to what we had gotten away from a little bit is you can file, now we can still file the petition for exemption from the moratorium, but that's going to be based upon breach or some serious breach, not just simply the failure to pay rent.
Yeah, and good luck with that.
And we don't know how they're going to, previously the court was entering those orders. They were granting those motions. Are they going to grant them now? We'll find out. We haven't done any of them yet because this moratorium just went into effect.
If we have a termination of term, but the judgment was paid, can we still file the alias?
Legally, I believe you can. There's no reason to stop that. You agree, Paul?
Legally, sure. Actually, I don't know. Are they going to let you?
You know what? All these different questions or the questions, they're all good questions. And the problem is we don't know what's about to happen. We just don't know. So
Yeah, the bottom line is you can ask me legally, what did the president have the authority to issue the CDC extension of the moratorium? I'll tell you no, legally he didn't, but he did. So do you have the right to lock the person out? Sure. Will you be able to? Probably not.
yeah, it's
great. It's great.
There
world
are no
we're living
answers
in right now.
Yep.
Please give exact contact for the national real estate lawsuit. I will give that to Priya, if that's okay, Priya, and she can get it out to all those that are looking for it or get it on HAPCO's website or whatever else they want to do with it. That's okay.
Yep, we'll put that on the website.
If you get money from rental assistance, but not the full amount and have a breach, can you get lockout? 10 of those twice as much as assistance, you're gonna have to wait 90 days before you can file. If you've gotten any money from rental assistance, even though it's not the full amount, you got some other reason, again, it's not the legal answer, it's the practical answer of what's gonna happen. They're gonna make you wait that 90 days, I can guarantee it. All right, I think, can you file tenant for fraudulently pay stub an application under the small claims? Sure, you can file suit against anybody for anything. So it's actually fraud. It's actually a criminal offense that you could file against them if they fraudulently lie on that application. Good luck in trying to win that one now. Just saying. So I think that's all the questions. If Kenny, you don't have anything else, I think we can.
I don't
conclude
think
this call.
so. I don't think so unless there are some specific questions, but no.
You know what? I'm actually looking right now. I see the CDC actually just came out, believe it or not, with a new mask mandate. They're saying that you should not wear an Eagles mask because it provides no defense. and with that, I want to thank you all for coming. And until the next one, take care all.
Thanks, Paul.